Nikki, just testing the volume. And can you hear us?
Yeah, I can hear you clearly.
Oh, brilliant. I just want to, because we are a minute away, I just want to test.
Okay. Welcome. Welcome to this fifth session of the International ADR series organized by the Thailand Arbitration Center. Our topic for the discussion today is ethics and professional responsibility for arbitrators and arbitration practitioners. It reminds us of Johnny Vidya's conundrum of the professional rules applicable to an Indian lawyer in a Hong Kong arbitration with Bahraini and Japanese parties. Such diversity of practitioners and parties raises a question over the applicable professional rules and rules with primacy in a system that involves national law, professional body rules, guidelines issued by arbitral institutions, and in some cases, treaties. The session will cast a light over the current framework and whether a uniform and binding set of professional rules will resolve conflicting standards to level the playing field. We have a stellar panel of speakers today. And as such a topic demands from three different jurisdictions, including the UK, New Zealand, and Singapore. I'll briefly introduce our speakers in the order in which they will be making their presentations. First will be Anil Changarath, who's an advocate and solicitor and managing director of Changarath Chambers based out of Singapore. Anil has been recognized most recently for his work relating to Singapore Law Society's Smart Law Practice and awarded the Law Society's Ad Hoc Pro Bono Services Assistance Scheme Champions. Next will be Jonathan Kaplan QC, who is a barrister at 5 Paper Buildings. Jonathan is a recorder of the Crown Court, master of the bench of Gray's Inn, co-head of Chambers, and former chairman of the Public Affairs Committee of the Bar Council, among his other illustrious designations. Finally, but not least, Robert Kirkness, who's an arbitrator and barrister at Thorndon Chambers, recognized by Who's Who Legal as a practitioner with excellent advocacy skills and someone bound to be a star. Before we start with the presentations, just a reminder that we will be accepting questions for the panelists at the end of their presentations. Please submit these questions through the Q&A box and identify the speaker for which you wish to direct your question towards. To kick things off, we have Anil, who will provide a broad overview of ethics and professional responsibility and touch on the challenges that arise in the context of international arbitration. Anil, over to you.
Sorry about that. Thank you, Nikki, for the kind introduction, and then thank you for the center for inviting us for the series. I hope this will be an engaging and exciting session. And if I may just start, I think it is very important that we start off by considering what ethics and professional responsibilities are. Many of you may be familiar with that. Some of you may not be familiar with it, but I'll just give you a brief description of what that is. Now, if you take a look at ethics, it's essentially moral principles, nature of obligations owed, and carrying out duties such as the conflict of interest, duty of good faith, acting impartial, showing a level of impartiality, and when there are third parties involved, like an arbitrator, for example, or a tribunal, then whether those third parties are neutral. And very often, some of these things are set in codes or in guidelines, right, internationally. Now, so if you take that as the essence of ethics, and then you then frame it and you realize that ethical obligations are in a way like professional conduct rules or responsibilities. Basically, it's about us professionally acting in a professional manner, obeying the law, avoiding conflict of interest, or putting interest of the clients ahead of yourself, right? So that's what professional conduct is. So with this idea of ethics and professional conduct being a framework of how you should conduct yourself, what you can then look at is, for example, it can be complex at times, right? But if you go take a look at Google and then in Google ethics and professional responsibilities in your own countries, you'd find that there are a lot of guidelines for those things. So for example, the Chartered Institute of Arbitrators have got what is called a Code of Professional and Ethical Conduct for its members, something that was produced in October 2009. The purpose in the preamble of those code, it says that it is so that the members may be reminded of the professional and moral principles which should at all times govern their conduct, right? Now in Singapore, the Singapore Law Society also has got practice directions and guidance notes issued by the council to guide and direct practitioners. Another example would be the American Bar Association. They've got what's called the Model Rules of Professional Conduct. So what you find is that when you get into this area of ethics and professional responsibilities, it is not difficult to find enough material on it to give you some guidance if you're not familiar at all of how one should conduct themselves. But if you're a practitioner in your own countries, there would be rules and regulations that are set in place for you to how you conduct yourself in your domestic courts and domestic environment of resolving disputes. So now that I've just covered a little bit about ethics and professional responsibility, the framework for it, let's take a look at how it applies to ADR. Right now, many of you would be familiar with the term ADR as alternate dispute resolution, but for several years now, it's more of what it's called appropriate dispute resolution. The reason why it's called appropriate is because you have one, a consensual approach, which can include conciliation, negotiations, mediations, wherein parties themselves come to a decision and settle the dispute with some guidance from a third party, but not a third party making the decision. And then you have adjudicative, is where a third party comes on board, is brought on board to try and resolve the matter in different methods. The methods can be neutral evaluation, expert determination, dispute avoidance, and dispute boards, adjudication, and arbitration, where this neutral third party will determine the outcome of the disputes. So now the point that you must appreciate is that whether it's ADR, not necessarily litigation, still does not isolate the practitioners from the ambit of ethics and professional responsibilities. The ambit of ethics and professional responsibility cuts across all of these dispute resolution mechanisms. Now, if you then consider how international arbitration kicks in, right, insofar as ethics and professional responsibility, may I just start off with a guiding point. Our Honorable Chief Justice of Singapore, Sundaresh Menon, at an ICCA 2012 Congress, when he was at that point in time still the Attorney General of Singapore, in the opening plenary session, he spoke on the topic of international arbitration, the coming of new age for Asia, and where he said that arbitration practitioners today ply their craft in venues across the world on behalf of users from every conceivable jurisdiction. So if you're talking about across the world and every conceivable jurisdiction, you know that there are going to be difference in style, difference in approach, difference in how each parties conduct themselves, right? Now, Paula Hodges, QC, in a paper published in 2017, made reference to what I just said, but the Chief Justice of Singapore had said. And he observed, this QC had observed that a significant increase over the past decade in the number, this is in 2017, a significant increase over the past decade in the number of international arbitrations taking place, and the expansion of practitioners practicing in the process necessarily renders the question of ethics an important but increasingly difficult one to address. So, you know, people have across the world realized that with international arbitration involving so many different parties, there will always be concerns about ethics, and there will always be concerns about professional practice and responsibility. Right? Many of you may know Gary Bourne. In his book, International Commercial Arbitration, published his second edition, he said that professional conduct rules of many national bars either expressly or impliedly regulate the action of lawyers admitted to practice before the bar and during the representations of the parties, right, to an international arbitration. There is no arbitration exception or international arbitration exception for most national rules of professional conduct. So what it's saying is that just because you're practicing arbitration or international arbitration for that matter, it doesn't mean that the rules of professional conduct get thrown out the window. You must keep those things in mind, right? So then the question then arises as to what exactly are the ethical considerations that arise in international arbitration. Unlike litigation, international arbitration involves parties, lawyers, arbitrators from different jurisdictions and can be complicated by differing cultures, practices, norms, reflecting a regulatory gap in development. That means the regulatory framework in these various countries may be very different. So then how do you then deal with it? The increasing globalization of arbitration is resulting in increasing need to consider and confront the diverging ethical standards because there are so many different standards. How do you then deal with it? Have you brought is there a lack of clarity as to which rules you follow, which procedure you follow, whether it's a civil law jurisdiction or a common law jurisdiction, and whether their practices are different? How do you integrate all of these things? You need to consider all of those things, right? Now, I'd like to just highlight two prominent cases along these issues of ethics and professional conduct. The first one is called, it's pronounced as, I hope I've got the pronunciation right, Hrvatska Elektroprovincija against Slovenia. And the second case was Rompotal versus Romania. Basically, it was a question that there was a challenge insofar as the counsel, because it was found that the counsel acting for one of the parties was working in the same chambers as a member of an arbitration. Interestingly, in the Slovenia case, the tribunal said there was no issue, right? And this allowed, there was an issue, and they disqualified the counsel because they felt that it was inappropriate for the counsel of one of the parties also to be in the same chambers as one of the tribunal members, right? But whereas in the second case, the Romanian case, they avoided looking at the first case, and they said that there wasn't a problem, and they allowed the party to carry on in the case. So you see, you've got differing viewpoints of ethics and professional responsibility. Which way do you go with these things, right? Now, many of you in this area of ethics and professional responsibility, there's a professor, Catherine Rogers, quite well known, and she had a book in 2014 that talked about ethics in international arbitration. And in that, she considered several things. She considered that international arbitration operates largely independently of national legal system, procedure rules, and confines of national legal cultures. Thus, often it's self-regulated. So international arbitration doesn't take strict guidelines sometimes insofar as one particular country is concerned. She also considered that while international arbitration arbitrators and practitioners have traditionally shared an understanding about the various issues arising in their practice, globalization has to some extent broken down the several the idea of this understanding and broken it down as to being not sure as to which way you go with certain aspects of procedure, certain aspects of ethics, right? She highlighted it in that book. She highlighted there were some important questions that needed to be considered: conflicts, impartiality, obligations of the party appointing the appointed arbitrator, the effects of experts or third-party funders, for example, all can have an effect. She also considered that despite international arbitration, impressive growth and obvious maturity in the recent years, there have been increasing disputing international arbitration procedures. So there are disputes insofar as procedures are concerned. Many questions remain unanswered about the ethical duties and responsible professional conducts that should be carried out and should be exercised. Whether or not specialized ethical rules should be set in place. So what happens is basically that you find that when you're operating on an international platform, these concerns can be a little bit more critical because you don't know how to balance it from one country to another, one council to another, one tribunal member to another, whether they adopt different styles, all right? She went on to describe several other points of concerns in her book. And what comes out of it is this: what kind of guidelines are there internationally? What I'm going to do, because mine is just a broad idea and the framework of our talk today, I'll just briefly mention a couple of them. The International Bar Association has got this thing called the Guidelines on Conflict of Interest of International Arbitration, which was published in October 24, commonly used when making decisions about prospective appointments of arbitrators, conflict of interest, disclosures, impartiality, independence, waiver by the parties. That guideline sets out there. The IBA also has guidelines on party representation in the international arbitration. This was something that was published in May 2013. All right, so several years ago, they have guidelines that set out framework. And insofar as party representations, it talks about party representation in international arbitration may be the subject of diverse and potentially conflicting body of domestic rules, norms, including home jurisdiction, arbitral seat, place where hearing is held, and ultimately to ensure the parties' representatives act in an integrated, with honesty, and should be not engaged in activities that are designed to produce unnecessary delay in expenses. So this guideline on party representation provided a framework for that, right? Now with these guidelines, there are still concerns. You know, the guideline sets out that it's only a guideline. It's only if parties enter into an agreement to follow the guidelines. It's just best practices. There are questions of how do you then impose on one of the parties or one of the councils who do not conduct themselves in an ethical fashion. There are these concerns that while you have these guidelines internationally, how do you enforce them? How do you take them? How do you hold one party responsible? Is it the tribunal then that considers these things? Because don't forget, a tribunal in an arbitration is there to really to decide on the party's case. And at the end of the day, only must focus on what the case is about, what the evidence is presented, and come to an award. They cannot be spending time canvassing or policing the councils that are involved. So the question then is, who then will take charge of all of these things? So I mentioned the IBA. In Singapore, we have the Singapore International Arbitration Center's Code of Ethics for Arbitrators. The American Bar Association, which I had mentioned previously, has this model rule of professional conduct. It also has a code of ethics for arbitrators in commercial disputes. So it sets out a framework. Again, it's still a framework. It's still a guideline. How do you then canvass it? How do you then enforce it? How do you then discipline it when you're dealing with an international arbitration matter? The last example there was the International Institute of Conflict Prevention and Resolution had in 2005 released a code of ethics for arbitrators in commercial disputes. So it's like some of the examples I gave you relate to the practitioners. You have this International Institute of Conflict Prevention and Resolution deals with the code of ethics for the arbitrators specifically. You know, because as much as you have counsels that may not have conducted themselves in an appropriate fashion, you could also end up having the arbitrators themselves not conducting themselves. So in concluding remarks, you know, the question then is, how do you get this all in order? How do you then ensure that it's monitored and managed in a fashion that does not hinder the primary objective of international arbitration? Is to come with an award that is workable for the parties, in the interest of the parties, and not have to focus on the conduct of the arbitrators, the conduct of the councils, for example. Now, the former Attorney General V.K. Raja, Senior Counsel in Singapore, in his speech at the Singapore Institute of Arbitrators in November 2017 said that there has in recent times been much hand-wrangling within the international arbitral communities about the difficulties of reaching a consensus on ethical standards and ever reaching the holy grail of convergence. The question then was whether or not there should be in place an international standards that everybody can follow, right? Interestingly, the Swiss in 2014, the Swiss Arbitration Association called for the creation of an international body, the Global Arbitration Ethical Council. So several institutions were called upon: the Chartered Institute of Arbitrators, the International Bar Association, the International Chamber of Commerce, the Singapore International Arbitration Center, the Swiss Arbitration Association, Stockholm Chamber of Commerce, Arbitration Institute, and the Vienna International Arbitration Center all came together and worked in a working group to see whether or not this Global Arbitration Ethical Council could be set up to monitor and discipline internationally. Now, the interesting thing is that after 2 years of reviewing it, they found that, that there weren't really that many cases lodged or complaining nationally in national courts about ethics and professional responsibility of parties in the councils or the arbitrators in international arbitration. And they felt eventually by 2016, they felt that it wasn't the right time for a global council to be set up to monitor, administer, and discipline ethics and professional responsibility. So I leave you with this point, that have we reached the stage that there needs to be greater discipline and greater control internationally insofar as ethics and professional responsibilities are concerned? To decide that, one has to consider whether or not there are that many cases of problems with counsels in international arbitration or arbitrators in international arbitration. And if there is, then maybe we should revisit this idea of having a global standard, a global framework on monitoring and administering and managing ethics and professional responsibility. So with that, I end my part of the presentation, and we can deal with some of the issues that I've discussed along with my co-speakers at the end in the Q&A session. Over back to you, to Nikki.
Thank you, Anil, for that fantastic overview and capturing the framework and bringing to light the fact that practitioners are still not completely isolated from their local professional responsibilities through their bar associations, and there's no exception to international arbitration and the rules of professional conduct, and also raising the fact that are there sufficient cases to require an overriding set of rules in order to control and direct professional conduct. But you also raised, on the flip side, the issues of the lack of uniformity and the issues of enforcement. And I think it's a good segue into what now Jonathan will be covering, who will be sharing his views on the limitations presented by the current system of regulation and enforcement, and share with us a possible solution to this. Over to you, Jonathan.
Thank you so much, Nikki. And thank you for inviting me to add my contribution to the discussion and to join with Anil, yourself, and Robert in this. And to Thai attendees, I simply say Sawadee Krap. I think the question which we're of course looking at today of how to apply ethical standards to international arbitration is one which we all know is a very familiar one. If you were doing an exam tomorrow in international arbitration, I'm sure this would be one of the questions in the paper, and you would get many diverse answers. One of the reasons may be that, as Anil has just referred us to, that of course with international arbitration, you're dealing with a huge diversity of participants from many, many different backgrounds, a legal Tower of Babel, if you will. And of course, the question then arises, giving due weight to the ethical backgrounds and practices from which different representatives originate and different parties originate, how do you regulate in a way that is acceptable, fair, and balanced? I'm bound to say from my perspective, which I know is not widely shared, I think it's a surprising element that the issue of ethical standards and their application to international arbitration has not by this stage been better resolved, and that there is not a greater consensus. There are certain fundamental principles which I'm sure we all would sign up to. There's no doubt, for example, that international arbitration must aspire to achieve the best standards, not only in its awards, but with regard to those who are participating, its process, its integrity. There's equally no doubt that we should not have a world in which there are higher ethical standards in national court proceedings and lesser ones before arbitral tribunals. Nobody wants to see that. And so therefore, what really is the focus of the debate? And we must recognize in striving to achieve the best standards and ethical precedents, that with the growth of international arbitration, the likelihood of a greater incidence or number of ethical breaches is very real. And of course, those are potential breaches by both arbitrators and advocates or representatives. I suspect that when we talk about ethical conduct and representatives or advocates, we are principally concerned with conduct that is disrespectful towards the tribunal, conduct which frustrates the efficient progress of the proceedings, and regrettably, varieties, I suppose, of conduct which can be termed dishonest. I mean, we must recognize that that is conduct which, albeit rarely, arises or has the capacity to arise. With arbitrators, we are concerned principally with undisclosed conflicts of interest, competence, unfairness in different forms. And if we were dealing with a more serious misconduct, then of course there would no doubt be criminal sanctions in certain cases. And for example, in the event of corruption, domestic criminal law would apply to regulate those kind of circumstances. But clearly regulation there must be for the integrity and efficiency of the process. Now, I believe that there have been two viewpoints which have contributed to a failure to resolve a widespread application of a code for ethical standards in international arbitration. Firstly, I think we need to look critically at the belief which has been advocated by some and some very responsible and well-known advocates, the belief that international arbitration should be a flexible dispute mechanism which is based simply on an agreement to arbitrate in good faith, and that arbitration should not become too fixated with rules which may not be, or which may not all be familiar in a party's domestic jurisdiction. Some have said, and they've made a plea, not to regulate arbitration out of existence. Now, my own view is that that belief, let's not regulate arbitration out of existence, is or could become a license for tolerating lower standards. A second viewpoint, which I think has resulted in a lack of progress, is the belief that the whole question of ethics is something that should simply be left to the existing ethical codes promulgated by local bar associations, and that at the end of the day, they should be the ones to regulate misconduct. That is clearly impractical, as a number of articles you'll easily find, made clear for a number of reasons. Firstly, there is often uncertainty as to the application of these bar association codes overseas, especially in quasi-judicial proceedings. Secondly, as we all know, there are notable differences in the standards of different bar associations, and therefore the very real possibility of opposing representatives conducting and presenting their cases according to different rules is one that is unattractive and unfair. Thirdly, not all representatives before arbitral tribunals are lawyers belonging to professional associations, and therefore would likely remain unregulated on this scenario. Fourthly, legal teams are often multinational, bringing into play different rules. And in any event, one has to contemplate how a local bar association will effectively interact in practice with the ongoing progress of arbitral proceedings. So in my respectful submission, relying or looking to local bar associations is not going to be and has not been productive. There are, of course, some bodies, and Anil's, or I think already referred to the Chartered Institute of Arbitrators, which have a well-established procedure for dealing with complaints against their members, whether in their capacity as an arbitrator or as a representative. But these procedures usually operate after the arbitral process has concluded, and the practical focus, I would suggest, needs to be on what the arbitral institution or the arbitral panel can and should do to regulate its own process. So I turn first then, please, to the arbitral institution. I think there is every reason for an arbitral institution to implement a set of ethical rules or principles, and to publish that as an annex to its arbitral rules. Those would then apply to all arbitrations under its aegis or control. As you may know, the first attempt by an arbitral institution to set out an ethical framework for attorney or representative conduct was the London International Court of Arbitration. Its rules were binding, and I think the latest version is about October 2014, if I'm not incorrect. These LCIA rules or guidelines do, however, suffer from the fact that they focus too narrowly, I think, on specific types of impermissible conduct. And the sanctions to punish misconduct are fairly weak, principally a caution or a written reprimand. There is also, as you know, and I believe Anil referred to, there are the IBA guidelines. These are more comprehensive and probably are a better source for institutions to use as a model for attorney conduct. And there are 27 guidelines. And the idea is that parties by agreement may adopt the whole or a part only of them. Sanctions include, of course, admonishment and reflecting misconduct in the apportionment of costs. So the LCIA rules, the London Court of International Arbitration rules, are binding on all named representative as a part of the agreement to arbitrate. The IBA guidelines are probably best viewed as mere suggestions, which the parties may choose to incorporate in whole or in part into their arbitral contracts. And just staying for a moment with the issue of sanctions, of course, it is essential that if you have a sanction, enforcement is achievable. And it must be remembered that these are not actually full-fledged judicial proceedings, and sanctions, therefore, probably cannot go beyond admonishment, costs, and I know this is a contentious issue, a possible exclusion. But those are the range of effective sanctions which are perfectly achievable. I turn next to the arbitral panel. I think it's perfectly feasible for arbitral panels to discuss with the parties the adoption of an ethical code or set of rules or principles. And if there is agreement, these could then be appended, say, to the first procedural order. These could set out quite general ethical principles, such as a duty to respect the integrity of the arbitral process, a duty to assist in the fair and efficient progress of the proceedings, even a duty to act honestly. Now, we may think and assume that all of those are duties which should go without saying, but there is no harm and every advantage in reducing them to agreed principles or a code, even in general terms, which can be, as I say, appended to the first procedural order. And those general principles are then sitting there and can be applied to specific situations if they arise as necessary. Now, of course, one can go for much more detailed set of rules, but that is one relatively straightforward way, which I suggest works. And in any event, such rules or principles would be, and the ones you would want to adopt, would be consistent in any event with those generally applied in common law or civil law jurisdictions. And the tribunal would have the inherent power to deal with breaches in a proportionate and reasonable way so as to protect the integrity of its proceedings. And I think that inherent power is generally regarded as being there to utilize in such circumstances. So I would conclude my short contribution, which I hope has given some context to the need to confront the increasingly urgent issue of ethical standards. In 2020, there really is no reason why Professor Catherine Rogers' ringing phrase should still be true. And let me just remind you of that ringing phrase if you've forgotten it or perhaps haven't seen it. What she said was, international arbitration dwells in an ethical no man's land. And I would suggest it behoves us all to do what we can to show that times have changed. Thank you.
Thank you, Jonathan. I think you canvassed a lot of the issues currently facing the system, looking for best standards and standards that are not too different to other judicial or dispute resolution proceedings. Also flagging up the issues of leaving of the arguments for flexibility of allowing parties to arbitrate in good faith and not being fixated by hard rules, and the limited reach of local bar associations where differences in standards obviously is unattractive and unfair, as you say it is. And also the powers that arbitral institutions and arbitral tribunals have, perhaps to deal with this issue in a very pragmatic way, by issuing sanctions perhaps for failure to conduct themselves in accordance with the rules published by the arbitral institutions, or a procedural order of the tribunal itself. But the actual scope and substantive scope of what these rules entail obviously will be a question for much debate. We now move to Robert, who will be moving to discuss the recently published draft code of conduct for adjudicators, which has been prepared by the UNTITLED and ICSID secretariats. The code has been issued in the context of the work being carried out by UNTITLED Working Group 3, which has looked at, which has undertaken a comparative review of the standards found in investment treaties, arbitral rules, and international courts. Over to you, Robert.
Thank you very much, Nikki, and thank you to Anil and Jonathan for providing such thorough and carefully considered remarks. They set me up very nicely, in fact, because Anil, your question, I think, is precisely the one that UNTITLED and ICSID have together decided to take on, and their answer, at least at this draft stage, is a resounding yes, it is time to have something more than the no man's land Jonathan referred to. And so they have, as Nikki alluded to, come up with a draft code of conduct for adjudicators and investor-state dispute settlement. So we have a partial answer, at least, to what Anil is saying, and I think it ties in nicely to Jonathan's comments around integrity and the importance of aspiring to that integrity and confidence, I would say, because what we see here, I think, and one of the reasons why we're seeing this development occur in the investor-state dispute settlement space is that, as you all know, legitimacy concerns are particularly acute and particularly acutely felt by participants in that space. And so I think that is partly why we see now two of the most instrumental organizations involved in that area mobilizing to come up with standards that can be followed, that can hopefully give some of that confidence and reassure stakeholders that there is integrity here in the way in which investor-state dispute settlement operates, and particularly in the way in which adjudicators, and we'll come to that phrase shortly, or that term shortly, conduct the proceedings. So I have 6 points that I want to cover briefly in my time today. First, the genesis of this draft code has already been touched on by Nikki, but I think it's worth bearing in mind that it operates, I think, in two ways, or stems from two sources. One is the general concern that I've already been discussing, which is a concern around legitimacy in investor-state dispute settlement. And that is a concern felt both by those who are fortunate enough to practice in it, but also external to that, people who do not participate in investor-state dispute settlement proceedings and yet watch and comment on what is happening there with, it seems, increasing amounts of concern and varying degrees of understanding of that process. And so we have a general backdrop from which I think we see this type of draft code coming. The more specific context in which it's come from is the one Nikki mentioned, which is initiative by the UNTITLED Working Group 3, which is looking precisely at investor-state dispute settlement reform, and ICSID. And I think the fact that we are seeing here a joint initiative from two heavyweights of the area is significant and should make us all sit up and take notice, both for what it tells us about the need for such a code, as Anil has already put the question to us, but also what the content is that is under discussion. So I just wanted to flag that this exercise is one that is being undertaken both by UNTITLED and ICSID, and the idea is that it will lead to something. That something is a working paper, and eventually, hopefully, at least from ICSID and UNTITLED's point of view, we will have a code of conduct that has been accepted, and I assume the plan is for consensus to develop around the standards in that code, such that one day we have something that is generally accepted in investor-state dispute settlement as the set of standards that apply and regulate ethical conduct, at least by adjudicators. So moving into my second point, what is it then that we're talking about when we say this code? And we've already heard comments from both Anil and Jonathan about the nature of the guidelines and standards that we have here. It's interesting that some of the directive that was given to UNCITRAL and ICSID in preparing this draft code, I think is slightly misplaced. The idea to have binding and concrete rules is a very nice thing to have in the abstract, but I think in this particular area, as both Anil and Jonathan have alluded to, what you generally find is that you have standards. Some of those may allow for some element of concreteness. For example, the code has a 5-year cutoff for disclosure of certain conflict situations. That is a relatively concrete thing, but it is inevitable in this area because of its nature, as Anil explained, that you will get judgment calls that need to be made. And so trying to make things binding and concrete is an aspiration that is worthwhile pursuing to a certain extent, but ultimately I think we have to accept that in this area, what you do need are standards. I think Jonathan was on point with that, and it is the specific situations that will be thrown up on a case-by-case basis that will allow us then to use those standards, however they are articulated, and start to develop a jurisprudence around them so that we start to give a greater understanding or obtain a greater understanding of where we see the particular boundaries being of ethical conduct. And that won't be something that sits in the same place for all time. It will be an evolving exercise, as these things usually are. So I think probably that's something that will be very gradually ditched by ICSID and UNCITRAL in favour of standards. And the attempt will be to get convergence around those standards. As I said, there will be some elements that remain hard, concrete, but most of this will be standards that allow you to make judgment calls and then an ability to assess whether those judgment calls were in fact correct. So I think the other point to flag at this early stage is just exactly where we're moving here, and that is that we have this document that's being created. It is open for written comments and they've been invited, so anyone listening to this should feel free to write in and give a helping hand to our friends at UNCITRAL and ICSID. 15 October 2020 is the time limit. What the code is at the moment, and that is obviously something that is currently undergoing or currently evolving, is a set of articles, which 12 and precisely. The first is a definition section, you then have a scope section, and then you have a duties and responsibilities section, which is Article 3, and that is probably the most important article, or those are the three most important articles. That is then followed by a series of articles that provide further elaboration on some of those general duties and responsibilities, and then ultimately there's some concluding points that touch on issues such as the ones Jonathan raised around enforcement and implementation. And I think in terms of the content there, what you see coming through in the document, and we'll dive into a couple of the specific areas, but to start with the end of the document, implementation and enforcement are difficult in this space. Enforcement in particular is something that a pragmatic and realistic view needs to be taken on. But when you get to implementation, that in turn will inform how you can enforce. So in other words, whether this code, as it will ultimately take shape, is something that becomes incorporated in the instruments through which there's consent for arbitration. That would be one way in which this code could be implemented. I think it's probably not as likely that that will be the way, but that's possible at least. Perhaps more likely is the way that Jonathan suggested these types of things can take effect, which is that the arbitrators themselves or the parties can initiate this in their dispute. So the parties to the dispute may decide that they wish to have some form of code included in procedural order number 1, and that would then be an easy thing to do when you had a code prepared by ICSID and UNCITRAL to use. And I think that is quite likely that we will see that happen. You could also include this type of thing in the procedural rules. That may be slightly more complicated, although not as difficult as incorporating it into treaties. And ultimately, I think there's some sense that you see as you read through this document that there is one eye on a multilateral dispute resolution mechanism in this space. Now, whether we ever get to that point is certainly something now that we see flagged up in a number of treaties that provide for the possibility that one day there will be such a thing. And so that's sitting behind this. But at least at this stage, I think the most likely course is that we will see this type of code be one that is adopted in the proceeding by the parties, perhaps at the initiation of the tribunal, perhaps at the initiation of the parties, and or through the procedural rules, particularly of ICSID and UNCITRAL, who are pushing this initiative. And that in turn, as I say, will have implications for what type of enforcement is possible. So the third point that I wanted to touch on is really the heart of these this code, which is the first three articles. And essentially, I think it's useful to look at it from Article 2, which is the application of the code. What Article 2 says is that the code shall apply to all persons serving as adjudicators in ISDS proceedings. Adjudicators shall take appropriate steps to ensure that their assistants are aware of and comply with the relevant provisions of the code. There are three concepts there that I think will be critical to how this all works. Adjudicators, ISDS proceedings, and assistants. They are each defined in Article 1. Adjudicators is defined broadly to cover arbitrators, but also members of international ad hoc annulment or appeal committees. So trying to capture not just arbitrators in a tribunal, but also annulment committees and ad hoc committees, but also in addition to that, judges on a permanent mechanism for the settlement of investor-state disputes. So there we see again some foreshadowing to what it appears is going to be part of the package of recommendations that we may one day see on ISDS reform. Assistants are an interesting concept that's introduced here, probably in reaction to a particularly controversial, notorious example of allegations about the relationship between a tribunal and a tribunal assistant, which means persons working under the direction and control of the adjudicators who assist them with case-specific tasks, including research, review of documents, drafting, and other relevant assignments. I think this is quite an interesting development. Obviously, the UCOS situation I was alluding to is well known, and this is something of a reaction to that. But what you see here now then is adjudicators are responsible for the compliance by their assistance with these standards. And so that's something that I think needs to be looked at carefully, and probably an area that is going to engender quite a bit of discussion going forward. Whether that is a good idea is not something that I'm sold on at this point, but it is nonetheless a reaction to a specific example, a specific concern that was very publicized at the time. The final definition that I want to focus on is that of investor-state dispute settlement, which simply means a mechanism to resolve disputes involving a foreign investor and a state, whether arising under an investment treaty, domestic law, or an agreement by the parties to the dispute. I think we're going to have to revisit that a little bit. It's incredibly broad and intended to be so, but at least the fact that adjudicators are defined the way they are means that we have some clarity around the types of, for instance, domestic court proceedings that would not be caught, even if they do appear to come within investor-state dispute settlement as defined. Now, the point I would simply make there is one of the things that might be useful as this document develops is, and you see this in a lot of ethical conduct instruments at the local level, domestic level, is examples of the types of situations that the principles are intended to capture. And that, I think, would provide greater clarity. The third article that I wanted to touch on in the sort of the core of this code is what's called the duties and responsibilities. And really, the main one of those, they've all been listed during the course of the discussions by Neil and Jonathan, but the main one is Article 3A, which is to be independent and impartial and avoid any direct or indirect conflicts of interest, impropriety, bias, an appearance of bias. So that is the overarching obligation and duty that adjudicators would owe under this code, and it covers a number of the core concepts that we will all be familiar with from different bar rules around the world. But it also, in this particular context of investor-state dispute settlement, raises some particular issues. So the fourth point that I wanted to touch on was one of those issues, which is conflicts of interest, which, as you know, a area of investor-state dispute settlement that gets a lot of coverage, and that is here the disclosure obligation, which is captured by Article 5. Article 5 is a more detailed expression of the disclosure obligation and conflict of interest part of that general obligation I read out from Article 3. And so here in particular, what attracted my attention were Articles 5.2c and 5.2d. 5.2c covers all ISDS cases in which the candidate or adjudicator has been or is currently involved as counsel, arbitrator, annulment committee member, expert, conciliator, and mediator. That triggers a disclosure obligation, and that disclosure obligation is one that reaches back 5 years. A list of publications by the adjudicator or candidate and their relevant public speeches. Now, it's really the last one that I think is interesting, because what this is doing is responding, at least in draft, to the idea of issue conflicts. And in recent times, a number of practitioners will be familiar with the wide variety of situations that different parties have alleged in investor-state proceedings can give rise to an issue conflict. And that can be everything from a situation where someone expresses a categorical view that they would never decide a case a certain way in a speech or article, which is fairly rare, fortunately, but also increasingly, and certainly in my experience, I've seen a few of these allegations where a party seeks to disqualify an arbitrator on the basis of a generally expressed view about the law and how it should be interpreted, set out in an article or a speech, and sometimes in another decision that is publicly available. I think personally that is a problematic area to start interfering with. For example, in a particular case I did, the allegation was made and the application for disqualification came about because of a concern around the way a particular arbitrator interpreted the definition of investment in an investment treaty. Now, if that's going to be the type of issue that gives rise to an issue conflict, and if you're able to trawl through the published works of an individual adjudicator and hold them to account for views expressed, then we're going to see some very unfortunate consequences from that, one of which will be that the quality of written work in this field will plummet, and we will get nothing but anodyne views, because nobody will want to jeopardize their ability to sit as adjudicators, or at least we will get views that do not include views of adjudicators sitting on cases, which are obviously a very rich source of analysis for all of us in commentary. And so I think there we have an opportunity, at least in the form of this code, to think very carefully about whether issue conflicts, as they're currently evolving and as we see that those types of conflicts coming through in the publicly available disqualification challenges in investor-state dispute settlement, an opportunity to just take stock of where that's going and whether there is the ability to clarify here precisely what is meant by an issue conflict. There will obviously be some situations where there is a genuine concern about what someone has said or done, but unfortunately I think at the moment the practice has gone a long way away from a sensible approach to the issue, and it would be useful, I think, to at least have some examples here of what ICSID and UNSTRAL have in mind by an issue conflict. So that's the fourth point. The fifth point, again, is one that comes up a lot, which is what's known as double hatting, wearing two hats. That can be in a number of different contexts, but most commonly it refers to a situation where a individual adjudicator may also be appearing as counsel. At that point, it gets confusing as to what precisely is meant, because we see this type of provision coming through in some of the more recent free trade agreements and investment chapters. Specifically in the TPP context, you have some concerns there about double hatting. And the interesting thing there is just working out what exactly would constitute double hatting. So, for example, is it another arbitration under the same treaty? Is it another investor-state arbitration? Is it another international arbitration? All of those issues are difficult in terms of determining the scope unless you get some guidance on precisely what it is that is said to be the concern here. And the related point that at least I hadn't considered but thought was useful in the commentary provided by Exit and Untitled to their draft code is that there's the potential, if this type of double hatting concern is enforced too rigidly, to act as a barrier to entry to adjudication, in the sense that often individuals will be seeking to become adjudicators, or may even just simply be nominated or appointed to be an adjudicator in one investor-state case in their careers. And in that case, it may be quite difficult if that person is transitioning from their status as counsel or their daily job in whatever other capacity to, on the basis of one case, suddenly disown all their other work and focus on the one proceeding they have. And I think that's a valid point that's been raised by those institutions, because although a lot of these ideas are worthwhile and should be explored, there is some risk in adopting too rigid a position. And that's again why I think one of the ways in which you can give guidance is through standards and potentially also some examples of the types of situations that are intended to be caught. Here in the double hatting context, I think, again, the types of things that would raise concerns become a lot clearer when you're dealing with specific circumstances. Finally, the other thing that caught my eye, and the sixth point I wanted to make, was one about pre-appointment interviews, which many of us will be familiar with as something that occurs frequently or not infrequently in investor-state dispute settlement, as well as other forms of international arbitration. Here, what we have is a requirement that that interview is disclosed, and that, at least as currently drafted, it be limited to the availability of an arbitrator and the absence of a conflict. Now, what that excludes, although what is quite common in practice, are discussions between a party or party's counsel and party-appointed arbitrators about, for instance, the characteristics that the party may be seeking in a presiding arbitrator, as well as commentary on a list, to the extent that a list of potential arbitrators is being exchanged between two adjudicators. And so there again, we have an opportunity to clarify, I think, the extent to which those types of situations, which are fairly common in practice, are going to be excluded. And if they are going to be excluded, I think it should be clear why. We can all see that ex parte communications between counsel and an arbitrator or adjudicators should not occur. That's not something I think there's going to be much difficulty in having people accept. But when you start to limit the communications in the way that this does, I think we need to be very certain that that is in fact the right place to draw the line. And so that's one of the reasons why the benefit of having a draft put out for discussion is that we can test this, provide commentary on it, and comments on it to Exit and Untitled for their consideration as they take this work forward, with the intention of a working paper and I assume an annex that will be a code. So those were the six sort of observations that I wanted to make in relation to what has been published as of May this year by Exit and Untitled. I think it's an interesting initiative. It comes at a time when I think we are conscious of the need for something like this, particularly in the investor-state dispute settlement space. I don't think there's any doubt about that anymore. So I think the initiative is a good one, but at the same time, now that we're doing it, it's actually the hard part where difficult decisions need to be made about the extent to which we are adopting rules or standards that will that everyone will be held to, and whether in fact we get those rules or standards in the right place. If we don't, then it's not going to have any benefit for integrity or confidence in the way that Jonathan was alluding to, and that is going to undermine the exercise. If it is done right, then I think very quickly we'll see a consensus emerge around the draft code, and my own view is it's likely that that will spill over from investor-state dispute settlement into other areas over time. So thank you, Nikki, and thank you also to Anil and Jonathan for their very useful comments that help give the context for my more specific focus.
Thank you, Rob, for that very comprehensive analysis of the draft code. You touched on the code being a solution to the legitimacy crisis currently within the investment arbitration sphere, and some of the binaries that are involved, which are the choice between concrete rules over standards, which allow to suss out over time what circumstances are appropriate and acceptable in terms of conduct. Also, the focus being put back on adjudicators, whether it is their compliance with the rules in relation to assistance, or whether it is in relation to the pre-appointment interviews, even though counsel hold a lot of the substantive content of what is discussed during the pre-appointment interviews, but the onus is put back on the adjudicators. And also the issues of conflicts of interest, where this could end up stifling a lot of academic opinion, academic debate. Perhaps you don't have to report this sort of commentary that you gave on the draft code at some later point in the future. So obviously we can see some of the issues that are raised with a code as this, and to what extent do you have to disclose your publications, whether you have to do it tomorrow, to what extent can you allude to constructive knowledge. A lot of the cases that the arbitrators are on websites of ICSID and the PCA. To what extent could you refer to those? So thank you all for raising a lot of the very interesting issues raised with respect to ethical and procedural codes of conduct. We have a few questions that we have received from the participants. The first question, and all of the panelists can perhaps see this on the chat box as well, is can the panelists please share their experience in adopting the IBA guidelines on party representation in their arbitration cases, whether on account of an arbitration clause or as part of a procedural order? I leave that to any of you to take a shot at it.
I think that the IBA guidelines say that they are inspired by the principle that party representatives should act with integrity and honesty and should not engage in activities designed to produce unnecessary delay or expense. And I think what you get is a fairly comprehensive list of duties and topics that are covered. I think it deals well with issues of disclosure, witness and expert evidence, and submissions. I think some say that there are key areas which are not included within the guidelines themselves. I think it's weak in failing to give clear indications as to powers or sanctions, which are largely left, I think, unspecified. It's also unclear as to whether or not you can exclude counsel under the IBA guidelines for repeated or serious misconduct. It does deal directly with issues with regard to requiring parties to identify themselves at the earliest opportunity, and it does give tribunals the ability to exclude a representation if it would lead to a conflict of interest. But exclusion on other grounds, I'm not sure that it really deals with that very well. So I think it's a good start. I think it's got a lot to commend it. Inevitably, there are going to be points which are not there and which people would like to see there, but by and large, I think I would give it a thumbs up.
Anil here, a couple of points. I mean, the question was whether or not I've adopted it. I haven't had a need to since the guidelines had come into place in 2013 and 2014. But interestingly, I was sitting as an arbitrator in a matter where the claimant was acting in person. And this was before the 2013-2014 guidelines. And what happened is that after I had the first meeting with the parties by conference call, the claimant filed a flurry of emails and copied in parties that were not in the arbitration. And we had close to 40 or 50 emails being sent out to various other parties and all that. So I had to repeatedly inform the party of his obligations insofar as confidentiality and the sanctity of the arbitration was concerned. In hindsight, I mean, if these guidelines were in place, what I would then have done is then call for a meeting and highlight to the parties, I think we need to set some framework and guidelines, and then let's take a look at the IBA guidelines. It's quite clear. Would parties agree to that? Right, and get them to sign on it. It's a point that I highlighted, that the guidelines are there where parties need to contract and agree to it. Along with that, I think Jonathan mentioned that sometimes you attach these agreements to follow the guidelines to the procedural orders. So that might be an approach I might have taken in that particular matter that I described as well, that I would set it out in the procedural order that let's say parties don't agree to using the IBA guidelines because this guy was a party in person. But in the procedural orders, I may make some directions insofar as the conduct is concerned. And in that particular case, all I had to do was to highlight the rules that were being adopted and the fact that confidentiality was a critical point, and highlight that in the order as well. So, you know, there are different ways of looking at it and how to apply these IBA guidelines. One, the parties can agree. Two, depending on the rules that the institutional rules that you're using, it might provide some avenue for you to input this in a procedural order. So these are some of the options I think I would consider.
Okay, we move to the next question that we received, which is, how do you overcome the problem of conflicting ethical codes of different bar associations? The most obvious is probably the difference between English and Welsh bar, prohibition on counsel preparing witnesses, and the American acceptance of such preparation as being the norm.
Yeah, I think maybe I could start with that because I think in the early part of my paper, I did speak a little bit about the different practices. So you have a situation where one of the parties may be represented by common law lawyers, and one of the parties may be represented by civil law jurisdiction. And then you have these questions about disclosure and what you can disclose and what you can't disclose and all of that. The tribunal really has to, at that point in time, suss this out and check with the parties, sit them down and ask them which set of guidelines do you want to follow insofar as ethics and professional responsibilities are concerned, because these may not be strictly, the fact that they come from civil law jurisdiction or common law jurisdiction and preparing the witnesses are not strictly under the rules of the institution that you have, institutional arbitration, for example. It does stamp a little bit on ethics and professional responsibility. So it's up to the tribunal to actually sit the parties down and their counsels and say, listen, we need to get this cleared up. Which form are we going to adopt? And let's put that out in the procedural order. Again, Jonathan's point about the procedural order. And that's what I think you should be doing in this matter.
May I just add, you see, I think it underlines the discussion that we've all been having. If you would, this is one instance, and there are others, of quite important differences between practices that are permissible under different bar association rules. And therefore, I think you probably have to say that arbitral institutions are best suited to formulate the ethical rules or specific rules for the particular arbitration proceedings that they oversee. And either the institution should set out the rules for attorney conduct, or if they haven't, then, as we've been mentioning, the arbitral tribunal can raise it with the parties, and you resolve it, hopefully that way by agreement, and incorporating it within the arbitration. But somebody needs to take the lead, and the arbitral institution is the best suited body to do that.
So I agree with the comments that both Anil and Jonathan have just made. I think I would add one thing based more on practice, which is there's every chance that the arbitral institution won't do that as much as it should. And there's also the possibility that a tribunal will not initiate this type of exercise, although again, perhaps it should if it's aware of just the varied nature of the parties. Another common issue that is very similar to the one that raised in the question is that of privilege, where you have different jurisdictions and even different cultural and historical approaches to confidentiality or expectations of confidentiality in communications between lawyers and their client, and that comes up all the time. What I think counsel need to do is take some responsibility for this type of thing, because we are often familiar with these issues, and most of us will get an opportunity to comment on procedural order number 1 in draft. I can't think of the last time that a tribunal simply issued it without giving the parties a chance to comment, and that is your opportunity to avoid a situation, because it is a lot harder to resolve these if you don't do it there. It comes up in the course of the proceedings and you have an argument about privilege or about the conduct of a party that somehow you became aware of. So you can't cover everything, but I think counsel have to take some responsibility. Agreeing with everything Jonathan and Neil have said, you also need to protect yourself and your client, and make sure that when you are aware of very common issues like this one, like privilege, that you put that in expressly so that there's a clear set of rules in the arbitrations that you're involved in, which is not a perfect answer to this, but it is nonetheless something that I think we should all be doing. And then as much as you can do that, ultimately, if this is going to be a systemic thing, then it needs to, I think, come from the arbitral institutions.
If I could just take that point from Robert's, exactly the point, then the question becomes as well, you know, he says parties as much as the counsels, and I mean the counsels as much as the arbitrator must be proactive in this. You know, Jonathan had mentioned these things about sometimes in the procedural orders, you want to put in, you know, duties of the parties need to be how they conduct themselves and all those things. You want to put that in the procedural order. A question then is where, again, I think Jonathan mentioned this. He says, you know, you don't want to be too regulatory in the conduct of the arbitration so much so that you put everybody off. But it needs to be a fine balance. The counsels and the tribunal are in best place at that. The minute we come on board. So for example, if I'm coming up against Jonathan, I know we're both in common law system. So we know how it's going to flow, and we know what's going to happen, and we don't think that's going to be a problem. But the minute if we have another counsel who's a civil law system, we must, as international practitioners, we must appreciate that their system is different. They follow different disclosure methods. They follow different cross-examination methods, and we must be very wary of that and straight off. You know, when the tribunal is going to be dealing with the procedural orders, suggest, you know, can we please take a look at this? Can we make sure that we've got all of this lined up so that we don't cross paths unnecessarily even before we start the arbitration? So it's really about being proactive. So you can't really, as Jonathan said, you can't really impose that on the institute, or was it Robert who said, you can't really impose on the institution to sanction all of those things. As the procedure is going to go on, as the hearing is going to go on, we ourselves must take charge, be guided by, or guide the tribunal into making directions and then suggesting a clear framework so that we can move these matters along expeditiously, the hearings.
I absolutely agree with the comments that Anil and Robert have just made about the counsel or representatives being proactive. That's absolutely fundamental.
So that ends the questions we have received from the participants. Perhaps I have one question, maybe on the draft code of conduct. Perhaps maybe Rob may want to take this. Is just on the question of double hatting, and maybe we can open this more generally as to what extent does the draft, or will the draft impede the progress of some of the first-time potential appointments as arbitrators or adjudicators under such a code?
I think it's a really good question, and I'm be very keen to hear from Jonathan and Anil on their thoughts too, Nikki. I think one of the ways that has already been identified, one of the concerns already identified by UNCTRAL and ICSID in formulating the draft code, is that when you are prohibiting double hatting, and let's take double hatting in a broad sense, so we're talking about, let's say, appearing as counsel in international arbitrations at the same time as you are sitting as arbitrator. Let's just use that as a premise that we're sort of dealing with in that context. When you're prohibiting the ability to do it, that may very well be fine if you have 50 arbitrations that you're doing. Someone mentioned Gary Bourne before, so let's use him. A lot of arbitrations that you're doing, and the ability to work hard enough that you actually don't slow things down, and so there, it's not really going to affect the individual too much to have that restriction. It may be bothersome, it may not be something they're happy about, but it's not too difficult for them because they're going to be doing just fine with their 50 arbitrations. Where you, however, have a young person who might be appointed for the very first time and maybe a partner at a law firm or sole practitioner whose main job is to act as counsel, then if you've prohibited the ability to do both, then you do start to see a concern that what you are in effect doing is creating a barrier to entry for that individual, such that there's just no way that for many people it's going to be possible to suddenly stop practicing as counsel in order to take up an appointment. And the related point that's made in the commentary that is also true is in investor-state dispute settlement, there will be a lot of people who do not do many at all in their whole careers. And so you might very well find someone who's appointed for one case, and that in itself is significant, but that would be a very difficult position to put someone in if they are a partner at a law firm or if they are otherwise acting as counsel. And the related point that sort of gets brought into this issue, I think, is timing as well. Because how do you draw a line as to when the person is doing the double hatting? Is it a particular time period within which you can't do these things? Is it that it has to be at the same time? How would you even know how that was going to play out? So I think those are the concerns that I've seen identified, and I agree that they are valid concerns that simply mean, and I think this goes to what I was trying to express earlier, that when you are having aspirational goals, like, for example, preventing the types of double hatting that we know are not ones that we would like to see occurring within the system of investor-state dispute settlement. When that's happening, we need to be very careful that what we're not doing is creating blunt rules that end up having effects or unintended consequences that end up, in this case, throwing up a barrier to something that we're all conscious of as being necessary in this field, which is that we have greater diversity and a greater number of people participating as adjudicators. So I think that's the concern that I see. I think it's a valid one. The answer to it isn't an easy one. As I said earlier, I didn't offer anything by way of an answer myself, but hopefully that's something that will be borne in mind. It's one of the reasons why I'm attracted to examples of fact situations or scenarios being included in the code, or at least in the commentary, to show what the real issue is that a prohibition or rule is driving at, so that when you have a general standard, you can use those for some guidance, and that's something that's not uncommon in bar standards.
Okay, from my take, starting point I must say is this. I feel that the use of double hatting, right, is making an imposition on the parties, the counsels and the arbitrators. The question is this: if I'm sitting as a counsel in a matter and it's an institutional arbitration, right? But at the same time, I'm also sitting in another matter as an arbitrator run by the same institution or the organization. I would clearly know where the balances and the lines are. You know, as a practitioner, I must make sure that I know where the lines are and how it's drawn and how you don't overlap between counsel in one matter and an arbitrator in another matter, right? So I wonder whether or not this is just a way that certain people are reaching out to say, listen, you're getting too many appointments either as counsel, as arbitrator, and it's unfair. But take a step back. We all are doing this role as an arbitrator, as a counsel in arbitration. We all are guided by principles that are set in well, I would say set in stone, because it's our culture, our nature, and that's what we do. And we must know how not to cross the lines appropriately, right? Of course, I know it sounds airy-fairy and that in the real world, we still have people crossing the lines. But I honestly believe that if we are proper practitioner of international arbitration, we will know exactly how it should be. And if there is a slight concern, the question is, what is your concern? Is it a concern that this person is getting too much exposure or too many appointments? Or is it a genuine concern that he may not exercise proper conduct, right? Then you really have a serious problem, because then from the word go, you mean you never had to trust in this gentleman as counsel or as arbitrator in the first place, just because they're double hatting at this point in time? Or you're just making an issue. So you got to go back to the fundamentals and then see the whole picture, and then consider whether really, is this a genuine issue, or is it an issue that people are just making up? You know, to that extent, I mean, I just want to add, you know, when I did my part, I said that there are many cases on questions of ethics and questions of professional responsibility. So the question then, and I told you that there was this suggestion of a global council, and the international organization sat there for 2 years, and they decided we were not the time for international council or global council. The point there again is this: even this issue about ethics and professional responsibility, is it such a prevalent, obvious problem that we need to really fall into a clear framework? Or is it just academic discussions that are going on repeatedly across the world? And so much so that we are wondering, oh, is there a problem? Do we think we need to put something, a framework in place and you know, sanctions in place and so on? Because when I did my research on this paper, I couldn't find as many cases. And exactly the Swiss Arbitration Center, in their suggestion of this global council, eventually realized that there was no need for it, right? So coming back to this double hatting, question is this really an issue that is going to affect the arbitration, or is just an issue about someone getting a lot more appointments than you know the others are? Sorry about that, but you know, that's my take.
Yes, I agree with Anil on this, and I'm going to backtrack on what I've been saying for the last, since we started, probably less regulation on this one.
Yeah.
The only point I'd add to what Jonathan and Anil just said is that I think it's probably a good idea to have clarity. Let me explain why, and clarity can also be making it very clear that there's no prohibition on double hatting, however that's defined. What happened in a recent investor state case that I had was that we had one of our arbitrators was also at the same time appearing as counsel. He was the party appointed arbitrator for an investor. He was appearing as counsel for a state at the same time, and the investor who had appointed him challenged him once they found this out, and they didn't like particularly the way the proceeding was going, challenged him, and what we had then was the need to argue about whether or not it was valid that this individual's in that position. Unfortunately, what happened, and this is why I think clarity is important, was that halfway through the exchange of comments that we'll all be familiar with that you need to go through, the gentleman resigned as arbitrator, which was less than ideal, I think, from just about every perspective, certainly from ours, and perhaps the investor may have been happy, but I suspect not so much. So there we just had a situation where the lack of clarity led to a situation where the process didn't get derailed, but certainly got stalled, and it wasn't the way in which you'd like to see your proceeding run. I think that type of concern is why we need clarity around this. The point I would make is that ICSID and UNSTRAL have now put this in their draft code. So one way or the other, we need to either say that it shouldn't be there, or it needs to be a very carefully delineated prohibition or restriction if there is going to be one.
John, Robert, I think that's a good point. I mean, the example that you cited, yes, it causes a problem. So if I was an arbitrator and I was a counsel for one arbitration, and I've been approached by the state, I would really have to think about it hard and make a decision. And I think personally, I mean, without the full set of facts, I would have to decline, right? And then consider that let me finish this particular arbitration because I need to it does cause a little bit of a conflict situation, and I can't deal with that. And instead of taking on the appointment and then like you said, halfway through the arbitration, then step down, you've caused far more problems than solutions that you could have addressed right from the start, right? And I think the parties, the states would appreciate you far better if you had done it in the right approach, the sensible approach. I mean, of course, in the particular case that you gave an example of, the circumstances may have been very complicated, and the arbitrator may really not have a choice in his decision, the initial decision. But eventually when shit started to hit the fan, so to speak, he realized, I really need to take a step back,
Well, thank you. And I think, one of the things with investor-state dispute settlement is the question of issue conflicts when you're dealing with double hatting and the fact that a lot of these issues are raised in cases after cases. And the other aspect is states can always deal with double hatting, and some have through treaty drafting. And so we see it one way or the other. It may feature in some form. Rob, did you have something to add, or we shift to the next question?
Shift to the next question, please.
So it's a more general question we just received, which is what are the criteria or parameters you set in accepting an appointment as arbitrator or counsel? Does anyone want to?
Is the question suggesting that you're coming into a double hatting or a conflict situation, or it's actually very wide, it can be a whole lot of aspects. It's quite difficult to think of an appropriate answer for that. I think that, again, it comes down to what all three of us were discussing. If you have a clear mind as to how your international practice is going to work insofar as arbitration is concerned, then you clearly would know where the lines are. In the examples that Robert had highlighted, it's really a call that you need to make. I really need to take a step back. If he thinks that being appointed as an arbitrator for the state is far more important, then decide whether or not you want to pull out from being a counsel to the party, right? But it's a decision that you need to think about it logically. It's actually a lot of common sense, I think, at the end of the day. Whether or not you're stamping on a conflict situation, or your integrity is going to be questioned, it's all common. A lot of it does come down to common sense. So if you take a step back and think about it, you'll come to the right conclusion. I mean, I know this is not a sensible example, but I had a situation where in a mediation, of course, a mediation, my role as a mediator is just to facilitate the parties coming to a resolution. I don't impose my considerations in that. But I had a situation where two lawyers came to me and they wanted me to mediate. And then I realized that I had acted for the defendants before. But the last time I acted for them was over a year ago, but we've spoken on and off. So I had to inform the parties, and the parties both said they were comfortable with it. I set out a clear framework saying that as a mediator, it's not me imposing, so therefore you don't have to worry about it. But having said that, what was interesting is that even as mediators, if you all have acted as mediators, you know that some of the times when you're sitting down and discussing with the parties, you don't make opinions and guide them through this thing, but you can size up where they're coming from, and you can ask them, relevant questions to lead them to a path that they can amicably settle. So in that situation, I set the framework clear, and I knew from the start how it had to be. Even though I'd acted for one of the parties before, the framework was clear when they entered into their mediation agreement before they started the mediation. It was very clear, and both parties had no issues about it. So in an international arbitration as well, I would assume that that kind of clarity must be set in frame right from the start. Now, some of the questions that may arise is that some parties may not be familiar with a common law system, and some parties may not be familiar with the civil law system, and they don't know. So in that case, I think you should ask the counsels, please explain to me how the procedure works insofar as the civil law system is concerned. Then once you have an idea of that, then you can set a framework of how the lines are to be drawn, where the conflict lines are drawn, and so on. All right?
Jonathan or Robert, anything to add in with respect to this question?
No, I agree. It's common sense, good judgment, and time. I mean, I think you have the best appreciation of your schedule, and I think you should always err on the side of caution, so you don't take on something that is going to be too difficult for you to deliver. And I think that's a golden rule.
100% agree with what Jonathan just said about time. It is absolutely something that I think people should be using as a criteria or parameter that they set in accepting appointment as either arbitrator or counsel. The only additional point to make, it's not one that relates to the criteria that I adopt, but I used to work for a large law firm, and that firm's policy was that none of the individuals working there were able to take appointments as arbitrators in investor state cases. So they could accept appointments as arbitrator in commercial cases, but not in investor state cases. And I think that's not an uncommon policy for law firms to take. So you do see there, from a firm's perspective, common sense in action, but I agree with everything that Anil and Jonathan have said, especially the point around taking into account your ability to actually discharge in a timely fashion the role you've accepted.
That brings us nicely to a close of this session. I'd like to thank, and on behalf of TAC, I'd like to thank all of you for your time. Thank you, Jonathan, Anil, Robert, for taking time out to discuss and share your very valuable and insightful perspectives on both ethics and professional responsibility for arbitrators and practitioners. I'm sure this debate will continue, and I'm sure we will have numerous occasions where we will be discussing these issues over and again. Hopefully, we will see more development in this area, and especially more rigorous critique and analysis of the draft code issued now by UNTITLed and ICSID. Thank you all, and hopefully you'll join us for the next in this series that is coming up. Thank you.
Thank you. Thank you very much.
Thank you.